I'm sorry.
Para
Not the correct. I'll just find that out, my lord, and in the meantime, I'll be ready. This one.
Now read that first plus item, you'll find it. I mean, though it refers to para 15 only, but para 15 is couched in a different way.
That expression is not.
The necessary law position has been explained. If the model key answer which is used for evaluating, the first one,
My lord, in case of erroneous evaluation where examinees are not at fault at all held.
No. If the model answer key which was used for evaluating the answer sheets was itself defective, the result prepared on the basis of same could be no different.
My lord, this is para 15.
But para 15 is different.
Now, it must be some other.
The division bench of the High Court was therefore perfectly justified in holding that the result of examination insofar as the same pertained to A series was vitiated. This was bound to affect the result of the entire examination for every candidate, whether or not he was a party to the proceeding. That's right. We don't find it in para 15. This
expression is not. Anyhow, my lord,
you rely on this.
My lord, now we are in the habit of control F. That is why it's become very difficult for us to find where in these books, my lord, control F is. Now, my lord, one judgment 2000. This is, my lord, Rachel and others versus Rajasthan Public Service Commission, my lord. 2018 8 SEC 81. Page 87. Page 81, my lord. 2018 8 SEC page 81. Para 15 and 16, my lord. Page 87.
You see the basis. Para 15.
My lord. At page 87, my lord. The issue pertaining to scope of judicial review of correctness of key answer has been considered by this court time and again. This court has entertained such challenges on very limited ground and had always given due weight to the opinions of subject experts. A three-judge bench of this court in Kanpur University versus Samir Gupta had occasion to consider a case where challenge was made to the key answers supplied by the paper setter with regard to multiple choice of the objective type test for admission in medical courses through combined pre-medical tests. The High Court, while considering the challenge of the candidates to various...
No, that's right. They have taken note of...
and para 16, my lord.
Including the one from Bihar, which paragraph 15, which is different from the plaster. And then, lastly, para 19. Please read it out.
The key answers prepared by the paper setter or the examining body is presumed to have been prepared after due deliberations. To err is human. There are various factors which may lead to framing of the incorrect key answers. The publication of key answers is a step to achieve transparency and to give an opportunity to candidates to assess the correctness of their answers. An opportunity to file objections against the key answers uploaded by the examining body is a step to achieve fairness and perfection in the process. The objections to the key answers are to be examined by the experts and thereafter corrective measures, if any, should be taken by the examining body. In the present case, we have noted that after considering the objections, key answers were published by the Commission. Thereafter, several writ petitions were filed challenging the correctness of the key answers adopted by the Commission. The High Court repelled the challenge, accepting the views of the experts. The candidates still unsatisfied have come up in this court by filing these appeals. This court, while hearing these appeals, found substance in some of the submissions raised before us. An appellant satisfied this court that certain answers need re-examination by experts. This court issued directions on so and so. My lord, the expression "no stone to be left unturned" must be having some value, my lord, in human existence.
Added to it would be that within a time frame, it should not disturb the academic schedule.
My lord, it cannot be.
Let's see.
It was the first instance, my lord, examination.
You also want to cite Vijay Singh.
Vijay Singh, my lord, we could not. My lord, para 15, it's there, my lord, in the middle somewhere. Para 15 of Rajesh Kumar and the state versus state of Bihar. 2013 4 SEC, my lord. It will be page 696.
Para 15.
Para 15, my lord, in the middle.
E.
On the right hand margin, my lord, you find E. The High Court has
Same, what we read in the plus.
My lord, yes,
All right. And Vijay, it has been summarized.
For the my lord.
Where it is? You have brought it.
2018 only, my lord. We could not get it here, my lord. I be for
Vijay, they say 1, 2, 3, 4, 5, 6,
This has
7.
been, my lord.
All right.
That is also 2018 only.
I would not remember the
My
year.
lord, we'll get. So I'll sum up by
Up
submitting,
till
my
now,
lord,
we have relied on Richel and Vijay.
my lord, that
Well,
judicial
deciding cases.
appointment.
All right. So you give a list of those questions where the answers are
Madam,
defective,
permission.
which requires a rechange. We'll put it to the BPSC. We'll
And
see.
my lord, there is no question of any inconvenience. That is their job.
No. That inconvenience to I mean, at what level? Inconvenience to students who believe. I mean, their statement should be taken note of.
The inconvenience that they are pleading, my lord, the commission, that it will get.
That we'll see.
That does not hold any.
Let's see.
Obligation.
Yes, Mr. YouTuber. तो फिर इनको कब शुरू करने कहेंगे? अब आज के बाद तो हम सुनेंगे नहीं.
I have still my objection in hearing him.
No, Mr.
No,
Shahi.
this is my lordship. This
We
vote
will-
should
we
not
will-
be allowed to be converted
Let us.
into.
No, it will not be. We just want to hear him 2 minutes. Yes. Not more than 2 minutes. Don't repeat.
My lordship, I will base my argument on the doctrine of legitimate expectation. The violation-
Doctrine of legitimate expectation. All right.
Point number 2, I will base my argument. Apart from the violation of Article 14 and 16, there is a violation of Article 21.
You don't
also.
have a legitimate expectation of anything. Legitimate expectation of your being given the opportunity of testing your intelligence, of being selected,
And also my-
in examination
and last
system,
point,
in recruitment process, there is no
My lordship,
legitimate
last point, there is a
expectation.
systemic failure which I will prove through the judgment which Supreme Court in Tanvi. Vanshika.
Vanshika, yes.
I would like to say, on what basis Supreme Court reached to the conclusion that there was no systemic leakage of the paper? It reached to the conclusion on the basis of the data analysis, and this data analysis was done by the IIT Chennai.
We have observed it in the earlier part of the discussions.
So the same point. Just
Mr. What is your name?
Pragesh Prasunso. Pragesh.
Pragesh.
Yeah.
Now, I had forewarned you earlier also. See, this is not the process of the court. Your petition is only in the pipeline. There is an objection to your being heard. But otherwise, we are of the view, cutting across all these technical formalities, that we will hear you. But if you repeat,
I'm not repeating, sir, but
we have read, for your satisfaction, we have read Vanshika, we have read Tanvi,
Yeah.
we have read all other cases that you
I'm
cite.
just saying, sir. I'm just saying. Just give me 2 minutes, sir. I'm just saying.
2 minutes, right by watch. We can
that-
extend it by 1 more minute, yes.
So in that particular judgment, the Supreme Court is right of comparison of data of each particular center year by year, previous 2 years. What my submission is that in the second re-examination, 4th January, the success ratio 19.6% on an average. But if we look at the success rate of 22 centers in aggregate, that may spike to 22-25%. Because my lordship, this is not a one-off event. Because in Delhi, what is study you have told, in Delhi, because we have option to choose the centers. That's why in Delhi the success rate is higher. Also, this is not a one-off event. In Delhi, always the success rate is remain higher. But in this particular case, this success rate is a one-off event. This is not a mere chance. This is not a mere coincidence. Rather, this is a systemic failure, which I will prove, my lordship.
Yes, 2 minutes more. Yes.
My lordship, in this particular case, what happened? This result have been prepared to 2 different exams have been taken, and this result have been prepared by merging the raw marks. This is where this entire problem has arisen.
Merging the
Raw marks of the two examination. The combined merit list have been prepared on the basis of the raw marks obtained by the candidates. On the
wrong marks. What do you mean by wrong marks?
Raw marks means what they actually what they have obtained in the examination. But my lordship, here the problem is that whenever examination takes place on 2 different sections, it is practice, then there has to be some methodology adopted. I would like to place my reliance on the very celebrated judgment of the constitutional bench, Sanjay Singh versus UPPSC, in which the only methodology was flawed, the entire result was cancelled. Only the formula was flawed. What I'm trying to say, my lordship, in this particular case, so what happened? The 2 results, 2 sections marks have been combined, and what happened? That the 90 marks have cut off have been framed for UR general. But point here is that, my lordship, 90 marks for section 2, like on 4th of Jan, and 90 marks from section 1, that is on 13th December. These are not same. Well, on private side, it may appear this numerical this is same, but this is not my lordship. This is what I'm going to prove my lordship here. My lordship.
Yes.
My lordship, on 13th December in Patna itself, there were more than 60 centers. None of the
Mr. Pragesh, this aspect is in our mind. This is in our mind, and therefore we have, let the BPSC answer. Now we are aware of that.
Now I would like to submit one more thing. NTA publishes result on the basis of this normalization methodology, and they based on this research, on basis of this research paper. This is the research paper. On the basis of that, they publish the result. This research paper itself says that when the examination held on multiple sessions, on the second page, my lord, or the second set of slides, it is written that when the examination is held on multiple set, then there has to be some methodology adopted.